Hey, what's going on, guys? Hope you can hear me. Just wanted to do a quick video. Not even a quick video, just kind of a sit down and talk about things video. Let you know that tomorrow, if you are in the Fort Worth area, hey, what's up, Peter? If you are in the Fort Worth area, Manuel Mata goes to trial on his quote unquote interference charge. Why does it, man, my background is terrible. I need to fix that. Let me figure out what's going on here. What? Oh, shush. Let's try that. That's a little bit better. Except I got a green glow around my head. Okay, it looks like crap, but it is what it is. See if I can get it better. Nope. I guess it's the... Oh, that didn't help any, did it? All right. Anyway, there it is. Just do that. Looks like junk, but it is what it is. You can kind of see my green screen underneath my microphone. Let's move that over. Anyway, hey, everybody. Tomorrow begins, if you are in the Fort Worth area, Manuel Mata will be going to trial for his so-called interference case. We are going up against a machine. Let's just put it that way. Give you a little bit of, fluorescent Rogaine. Give you a little bit of a story of where we are at this point right now. So Mata was out there. You know, he saw him and Caroline saw a police stop. They had pulled over for somebody for a DUI or DWI, whichever. And they were getting ready to give him an FST, the field sobriety test. And they came up and they were filming, you know, and this is the funny thing is they're sitting there filming, right? They're not bothering anybody. They're not saying anything. I think at one point they did when he was taking the field sobriety test. I think Caroline said something about, you know, you don't have to do that if you don't want to, kind of thing. And anyway, so a police officer goes probably an easy, I don't know, 50 feet or so away to tell Caroline and Mata, you know, he identified, oh, I don't care if you film. You know, they always start that thing. I don't care if you film, but, you know, and then they tell you why they care. You can, I don't care if you film. You just got to do it in a way that I think is correct. So the officer goes up there and for the rest of the thing, you know, they did what they were told to do. I mean, I wouldn't have done it, but they did what they were told to do and they stayed behind the line. Well, then the gentleman ended up getting arrested for a DUI. And then everybody left. And at that point, you know, once the guy was gone, the subject, he slightly radioactive. Yeah. Once the DUI suspect was gone, Mata went up and started asking, you know, for like names and badge numbers and stuff. And that's where it always starts. You know, it's funny because what's the first thing that the police ever demand when they stop you out there? It's like crack to them. You got any ID on you? You know, but by golly, when you turn the tables and you go up to a police officer and you ask them for ID and you demand their name and badge number, wow, you know, it's like the most offensive thing you can possibly do. And there's a lot of irony in that because, you know, the police are filming you on their body cams. They're filming you on their dash cams. They're filming you at the intersections. They're filming you in the streets. They're filming you in their buildings. They're filming you all the time. But yet when you film them, they get offended. And the same thing with stopping people. You know, if they go to, oh, we got to call, need to see some ID, or they just don't like what you're doing. Need to see some ID, need to see some ID, need to see some ID. But the minute that you demand that they identify, all of a sudden they get all pissy and look for ways to retaliate. And what can I charge this guy with? So that's exactly what happened. They at one point, Mata went up to the vehicle and he's filming, and the officer doesn't like it. and ends up telling him to stand behind some line. Now, keep in mind, there are cracks all over this parking lot where Mata is. And all he's asking is which line, which line. And when the guy doesn't tell him, instead of just, talking to Mata, he decides he's going to arrest him for quote unquote interference, claiming that he's filming private information. So what's interesting is there's a third thing. They talk about the open view doctrine, a plain view doctrine, that if you can see it from anywhere you have a right to be, they can use it as evidence, as probable cause, right? Well, the same thing goes the other way. If the police are doing something in plain view, then that has access to the public, then so what? But they arrested Mata and tried to claim interference because, I'm about to type in some personal information. Now, some stuff will come out in court, but if you're in Fort Worth tomorrow, his case has been moved to County Criminal Court number 9, County Criminal Court number 9 in Tarrant County. Same thing, Tarrant County. And it was supposed to be in court 1. That's the court that we've been in. That's the court we've been arguing in. And then we were getting ready for trial tomorrow. And on Friday, I believe, or maybe it was this weekend, got a note from the judge saying that what was I saying? You interrupted me. I forgot what I was saying. Oh yeah. And then, so there was another case that, at 9:00, starts at 9, but it's for Dyer. So we probably won't get to the actual trial until 1:00 tomorrow afternoon. So the judge said, hey, there's another trial that's ready to go. Another case that's ready to go. They have priority review because it's an older case. So we're going to reschedule your trial. And I was okay with that. I understand. That's the way it is. You've got, as an attorney, if my case is older, I'd want it to be dealt with quicker too. But then then there was a request to, well, hey, these other courts aren't doing anything. Why can't we just move it into one of these other courts that we haven't been in this entire time? So it got moved into 9, which happens to be the same one that Carolina was just convicted in, but have no fear. She didn't have me as an attorney, so I'm not worried at all. Whether I'm in court 9, court 1, or court 55, it doesn't matter. We're going to win this one. All right. It does help if there's some security. So it's County Court 9. If you want, you can be there at 9:00. That's when I've got to be there. But just keep in mind, that's when the jurists show up or the jurors show up, and they do like a pre sort of voir dire. They look for everybody that's got these statutory exemptions and kind of weed those out immediately. And then once all the statutory exemptions are weeded out, then they will send out the jurors to the respective courtrooms. And then that jury pool will get a regular voir dire by, of course, the attorneys in the case, me and the prosecutor. So, I've got you down as a moderator, Emily. All right. Anyway, so really what I wanted to do with this is try and raise a little bit of awareness to be there. And by tomorrow, for those of you watching, that's December 17th. Oh, December 17th. Well, they can see that you've got a wrench next to your name anyway. Is jury selection as secure as our elections? So the jury selection process as it relates to the jury pool is kind of it's supposed to be a very randomized thing. I've found that it's much more randomized when you go into the bigger counties because of the way that they do this, where you've got a jury pool like 200 or 300 people, because you've got so many courts in that county, like Bexar County, Tarrant County, and all those. And then once they do the pre-qualification, they just slice off the juries and say, okay, they go up, down. Okay, you go to court 1, you go to court 2, you go to court 3, going down the line. So, for the most part, it's a little bit more secure, but it depends on the size. Like I've had cases where it seems like every single person in the jury pool is a government official, and I'm like, whatever. But the good news is, and just so you guys know this, if you ever do a pro se jury pool, if you get a jury pool and they've they give you the sheets of all the jurors, so you got some biographical information of all the jurors. And if you see that, like, the first, the first grouping is, you think there's something suspicious about that, like it's been stacked. A lot of people don't know this, but you can do what's called a shuffling of the jury. And, you can, as an attorney, you can demand that. It's not even a thing. It's just you say, hey, I want the jury shuffled. I don't like the way this is laying out. I think it's, I think something's up here. So then what they do is they've got a computer program. They take all these names and they reshuffle the jury. And it reseats them, because, generally if you have a jury pool of about 50 or whatever, you've got a jury pool of 50. Keep in mind the first 12. So you've got juror number 1 all the way up to juror number 50. And you go through a system of questions, and there might be some people that, will ask the judge, say, hey, I've got this exemption or that exemption. And, you might lose 39, and you might lose 22, and you might lose number 6, whatever. At the end of the voir dire process, it goes down the first 12 people that haven't been dismissed from the jury or crossed out by the jury. And every attorney, every party has 3 strikes, 3 what's called preemptive strikes. So I can just say, for any reason, as long as it's not a discriminatory reason based on a protected status, I can strike 3 jurors just right off the bat. And let's say I'm trying to get to juror 15, right? Because I really want juror 15 to be on my jury. I've got to make sure that I strike at least someone in the first 12. Now, I can do unlimited strikes on what's called for cause. So, for example, if there's someone that testifies that they know Mata personally, they've watched his videos, they can't stand him, and they couldn't be unbiased, or even if they could be unbiased, I'd still get them for cause just for saying that they can't stand Mata, they don't like his videos and that kind of stuff. And so that would be a for cause. Those are unlimited. If you got a cause, a legal cause to dismiss a juror, those are unlimited. And then you've got 3 for any reason whatsoever. And that's how when I did the case up in Abilene, there were some people kind of deep in the bench that I really wanted to get through. Thankfully, the prosecutor and I agreed on many of the for cause people, so I didn't have to use one of my preliminary strikes on them. But we'll see how this goes anyway. That's tomorrow, 9 o'clock, County Court 9. And I'm going to do this. If there's anybody if you have StreamYard and you would like to kind of come on and ask a question or talk, this is a kind of a free-for-all today. And just a way to, if you haven't looked at the description, so I've started up what's called the 1791 Foundation, and it's a scholarship fund is really all it is. There's the link, by the way, if you would like to join on this. I will see you and pop up, and if you got questions or something like that tomorrow. I do not think they're televised in Tarrant County. I don't think they are. Yeah. So there's that. If you want to come on, if you got a question in the chat room, you're free to ask it. This is going to be, I think, tomorrow. So voir dire is going to be in the morning, possibly into the afternoon. It depends on when they're done in the morning. I guess normally they get done between 10 and 10:30, and then they get sent up to the courts. And then that's where, we might take about another 2 hours to do voir dire. And then we'll jump right into opening arguments probably tomorrow afternoon around 1 o'clock. but yeah, you can, anytime you get a jury, all you've got to do as a defense attorney, if you don't like the way that, anyway, once this is what I got back to. Once you've done all of your strikes, your preemptive strikes, as well as your for cause strikes, then the judge will go down from juror number 1 up to however many. So let's say juror 1 wasn't struck for any reason. So there's your first juror. And then maybe the next 5 were, and then juror number 6 was not struck. So there's your second juror. And then maybe the next 3 were. So then number 9 is your next juror, that kind of thing. So until you get 12 and you move your way up. And of course, there's different strategies for that. When you're doing voir dire. Like I said, in one case, I wanted to get to number 15. I needed to at least get to where he had a chance to be on the jury and be in the first 12. And we were able to for cause, I think three people from that first set, which brought us down to 9. And then he got in there anyway. So thankfully we had some good jurors for that case up there in Abilene. Prosecutors shouldn't have peremptory challenges anyway. If their job is to be advocates. Well, keep in mind their job, the job of a prosecutor is, and this is what I'm talking about. The job of a prosecutor, and I see you, Nissim, give me a second. The job of a prosecutor is, keep in mind, there are 2 parties, allegedly, when you get to a criminal case. You've got the defendant and you've got the state. You've got the defense attorney and you've got the prosecutor. The job of the defense attorney is to ensure that the defendant gets a fair trial. The job of the prosecutor is to make sure that the state gets a fair trial. And if there are jurors on there, as much as I would like to have them, that simply hate cops and think that, cops should be abolished. And obviously the state has an interest in not putting that person on the stand, and they wouldn't be able to get a free trial if someone just came in and they were completely anti-government or whatever. So that's why they get peremptory strikes. And quite frankly, they should have peremptory challenges, because if there's bias in the jury one way or the other, both parties deserve a fair trial. The state deserves a fair trial, and the defendant, most especially, deserves a fair trial. So there's that. Hey, what's going on? Ian is out there. Deacon. Yeah. Oh, I don't see it. I'm on yeah. All right. So we got somebody here backstage. I'm gonna bring them on, see what's going on. We've got Nissim here.
How you doing there? I've been a follower of you for a long time. I do have a question that dates back that long, however. Yeah. Do you remember delivering notices to cease and desist to the different municipalities down in Texas and all that? Can you tell me why? Well, can you tell me why you actually delivered it before you actually filed anything? I mean, it's not often we see somebody delivering notices, of that nature, and informing them of the laws that they're breaking and giving them the option to continue to break them. So I thought that was one of the most exciting things that you've ever done. And I think that would be a strong point for anybody out there facing legal litigation.
So my philosophy is, especially when I'm suing government entities, right, is there's no such thing as a private lawsuit, because anything that they do, when you have to hire attorneys, when the city has to hire attorneys, or the county or the police department or whatever, they're not paying for that. You, the taxpayer, you're paying for that. Not only are you paying when your rights are violated, you're paying people to violate your rights. Now you're actually having to pay people to defend the people who violated your rights. And so what I try to do is I try to avoid litigation to the greatest extent possible. If we can work on a settlement, that's best. But I give out the notice for several reasons. The first and foremost, it's to try and avoid and solve the problem at the lowest level. If I can do that, then there's really no need to engage in an expensive, protracted legislation. When in effect, it hasn't hurt us. Putting up a sign, it doesn't really hurt you. There's no damages there. Why would you spend a whole bunch of money? Unless, of course, you personally went in there knowing that the signs were invalid, and then you got arrested. Well, now you've got a bigger cause of action. But the goal is to avoid those causes of action where there's no damages and you're not going to get a good judgment. That's the first and foremost, is to try and avoid that litigation, because avoiding litigation saves taxpayer dollars. And as a a little L libertarian. I'm all about saving as many pennies as I can because the government's stealing it all anyway. Second reason I do that is because it puts them on notice. When I write these demand letters, I include case law, I include statutory law, common law, I include everything in there in my argument. It's almost as if I write the lawsuit in the demand letter. And this is essentially a first opportunity for the city to do something right, to do it, to do it right, to stop doing whatever it is that they're doing. What's that?
Doesn't that change their implied immunity as well when they have knowledge and they actually have the law in front of them and they choose to violate that law? Doesn't that also apply and remove their implied immunity?
Well, and that's what I was getting at is once I've given them my demand letter and I've explained what the law is, if they continue to violate the law, despite the fact that they knew better, that puts them on notice that, okay, well, you've got no qualified immunity now because I educated you, you knew what the law was, and you decided to ignore me. So the second letter that I usually send is what I call a settlement demand. So first I just send a demand letter. That's, look, stop with your unconstitutional actions. Here's what you're doing wrong. Here's why it's wrong. And, here's what's going to happen if you don't fix it. And then I give them, usually depending on what it is, like if it's something like blocking someone on Facebook, I'll only give them like a few days, like 4 days or something like that to unblock people on Facebook. If it's something like a big, for example, like where Harvey, for example, was searched unlawfully just because he had a camera. Like the cop comes up to him and he says, hey, I don't have a problem with you filming, but I'm going to search you for weapons. What? No, that don't work. So that's a violation of rights. And then when I sent a letter explaining that, look, you violated my client's Fourth Amendment rights. Now, obviously, in that kind of a thing, there's not an ongoing issue. It's already happened. It's over with. So I just told him straight up, look, if you would like to avoid litigation, so would we. Here's a very modest offer for a settlement to avoid litigation. And in that case, they were essentially like, go pound sand. We didn't do anything wrong. Like, really? I mean, Terry v. Ohio, I mentioned Terry v. Ohio. I mentioned Turner v. Driver. All of the things that say you can't just search someone for any reason whatsoever. And yet here you are doing it and you think, okay, fine. So we filed a lawsuit. All of a sudden now they're wanting to talk. So I try to avoid that. And because filing a lawsuit's expensive. If some people come to me all the time, they're like, hey, I want to sue. I'm like, okay, you got a good case, but look, here's what it's going to cost to file a lawsuit. Right. And sometimes it's just the federal fees, but sometimes like if you're suing, I got one client, it was suing Amazon, but because of their arbitration agreement, it was going to cost a few $1,000s because you have to split the cost of arbitration. Oh, and by the way, you've got to sue them in California. So even though your rights were violated here in Texas, you've got to sue them in California, which actually you don't have to. You can sue them here in Texas on the long arm statute. But
that's a complicated jurisdiction thing where you have to show multi-jurisdiction and reasons not to be able to appear in the other jurisdiction then, right?
Right. And if you're doing business in a state, if a company is doing business in a state, even if they're not from that state that they're doing business in, there's a reasonable expectation that they could possibly be sued because they're doing business in the state, and that gives personal jurisdiction to the courts over that entity because they do have what's called minimal contacts and in the state. And so you just sue in federal court under personal jurisdiction reasons or diversity jurisdiction. Then that's how you sue. Yeah, diversity jurisdiction. All right. Was that it?
I'd like to congratulate you. And I do have a question about that. Congratulations on passing the bar. Okay, we need more people like you to be judges, not a lawyer. Hint, hint, nudge, nudge. But the other side of this is I want you to describe the effort it took you. And mind you, I'm 62 years old. So me and the concept of me going back to school is, prohibitive, or it has a intimidation about it. And I'm just wondering, scaled on 1 to 10, 10 being where you have just barely made it and you should be going to the emergency room. How would you rate the actual course for becoming a lawyer? And how long did it take you?
So it's a 3-year course. I think people can get it done in 2.5 years if they really pack their schedule. You could probably get it done in 2.5 years. 2.5 years and not really hurt yourself too much. But if you want to get it done in 2 years, just expect a very stressful 2 years.
That's going to be the emergency room then.
yeah, that's the emergency room. But it's 3 years. I did the 3-year program. I was in no hurry. I wanted to do it right. I wanted to take my time. I wanted to be able to focus on the individual subjects instead of having so many classes to worry about that I don't really remember anything. I will say that the first year is hell. I literally almost just, and I'm not a quitter, but I was like, yeah, forget this. I don't want to put up with this bullshit. It's not worth it. The first year of law school is incredibly hard. It's almost like boot camp, because what they've got to do is they've got to break you down and then build you up into a lawyer, because it's a completely different way of thinking. I would even argue it's not about thinking. It's about surrendering your thought process and then just kind of reading what you're supposed to do. It's kind of a weird thing, but it's the same thing as like boot camp, where they beat you down, then they build you up into a soldier. And that's what the first year is designed to do, because this job is very research intensive. If you don't like reading, if you don't like, there's a thing saying, after, what's the one thing that you can't get enough of after you get out of law school? And the answer is homework. Because that's all you're doing is reading, researching, drafting, reading, studying.
When you're doing the drafting, are you talking about drafting writs, motions, and things like that?
Writs, motions, complaints. Yeah, responses to responses, doing
so you're actually taught construction as well.
Say again?
You're actually taught construction in order to create these motions from scratch and what the requirements are, and that is what the tests are based on?
Yeah, so in our civil procedure class, the second semester, you start to learn and draft things a little bit. But I will tell you, at least in my law school, they did teach us, you've got to go through a legal writing class. That was mandatory in our first year. It was called legal writing. And then there was another one. I can't remember exactly what it was called. It was our first semester thing, but it's essentially understanding the basics of law. How does it work? Where does it come from? What are the basic elements of things like assault, or battery, or the inchoate crimes, so to speak.
What about the different types of writs? Are you expected to memorize like 50 different writs in order to take a test? Or
no, I was actually a little surprised, and I brought this up when I graduated because this was one of my recommendations for approval, is there should be more focus on motion writing or motion practice, understanding writs, what writs do what. When do you file a motion to suppress versus a motion to dismiss? And really, we didn't do a lot of motion practice at all, other than our civil procedure class. We went through all the civil procedure of a fake case, and from the complaint drafting to the response to the complaint to 12B6 dismissals, all the way up to drafting responses and stuff.
I hung out at the St. Louis University quite a bit. They had a restaurant right next door to it that was called, of all things, the Sidebar. And they served, BLTs and stuff like that. But they also, in the back, was constantly hosting mock trials. Did you have an opportunity in order to participate in mock trials, or how did they do that? Did they do that online, or can you explain some of that process?
Yeah, so I did both trial advocacy and appellate advocacy because I knew I wanted to be a trial attorney. And so there are, at least the law school I went to, it wasn't required. I don't know if it's required at other law schools, trial advocacy. And
well, I understand that if you're going to work with torts, you might as well start with taking a bunch of mushrooms. So torts are a nightmare, and it's as writ and as writ, not written. And it's a very bizarre world over there. But for being a trial lawyer and stuff like that, you're not exactly diving that deep into legalese, right?
Well, you kind of do. Because the cases that I take, you have to know a lot of legalese because you have to understand the rules of evidence. But you really have to understand motion practice because, you've got motions to suppress, motions to dismiss, motions in limine, motion to elect for a jury to determine punishment. There's all kinds of things in the Code of Criminal Procedure that attorneys have to be aware of. And then when you're aware of it, that still doesn't mean you can draft it. Like I know that what a writ of mandamus is, but how do I write a writ of mandamus? And law schools don't really.
What is its requirements? What is its construction? Yeah. Exactly.
And I'll be honest, what I do is, and I've always been a good writer. One of my professors' all of my professors, one of their biggest critiques of me as a student, they would say, okay, you've got this assignment due no less than 2 pages or 4 pages or 6 pages. And I would have to ask my professors, well, what's the max that I can write? And they're like, well, I ain't going to read no 20-page paper. I'm like, okay, well, you say the minimum's 4. What's the max? Like 6, 8, 12? No, 6. Actually, no, make it 5 for you, because I like to write. And I think the reason I've been so successful is that I don't just file motions and put in the bare minimum. When I file a motion, I'm thinking, okay, how is the other side going to respond to my motion? And then I try to preempt whatever their argument would be with my motion. So if it's a motion to suppress, I would lay out all this stuff, and then I'd be like, okay, well, how is the prosecutor going to attack this? They're probably going to go, obviously, they all go for qualified immunity. So I've got a really good attack on qualified immunity all the time. Because again, like we started out when you asked me, the way I do it is I put them on notice. So qualified immunity has always been easy for me to overcome because they knew they were doing it wrong. And
let's say, as an example, and again, I mean, I'm trying to find something that would relate to the audience, something, including myself, because I may have a position where I'd have to do this. But there is quite a few people that I have talked to that when they have submitted an actual complaint and followed all the rules and stuff like that, they submit it to a federal court, and being pro se, the first thing they do is kick it back. Now, I've heard the explanation. The reason why is they'll give you some reason that they didn't accept it and they would like you to improve it. But when you submit it the second time and they kick it back, and you know that you've fulfilled all of these criteria, what can you do in order to progress your case beyond the acceptance to the docket?
So the first thing that that people, if you're going to go pro se, what you need to understand is that you need to first understand, before you even fill out your complaint, there are 2 cases that are incredibly important to every single civil case, right? When you're going to sue somebody, and they're called the Iqbal and Twombly standards, right? I call it Twombly, some call it Twickball, because these 2 cases determine what is. Oh, and by the way, the Twombly case is 550 U.S. 544. That's from 2007. The Iqbal case, it's Ashcroft v. Iqbal, is 556 U.S. .66, or 556 U.S. 662. So it's a 2007, 2009 case. Really read those, because that explains what's required in a civil case for pleadings. Like if you don't meet those minimum requirements, for example, you can't just say that you are, suing for retaliation and you haven't pled each element of retaliation, right? One of the elements is that, the case was dismissed and that they went after you for a malicious intent. Well, if you just say that the case was dismissed and they had no right to sue you, or no right to arrest you, except for the fact that that you were an activist, right? Well, you can't just say it that way. You've got to say that they maliciously did so because of their disdain and hatred for having the eyes upon them. You've got to be able to explain the maliciousness element. And that's where a lot of people fail, is not understanding, okay, what am I suing for? I'm suing for assault and battery. Well, guess what? You can't do that in federal court, because those are state actions.
Really? I didn't know that.
Yeah. So they'll kick that back, because if you're doing for a 1983 case doesn't include assault and battery, believe it or not. I find it odd that, acting under the color of law, if they assault you, that wouldn't be included. But I mean, there's You'd learn that in your first year of law school. Why? And then, so if you need to know the Iqbal, and as a matter of fact, here, let me see if I can,
There's a good question in the chat. It says, how can a judge change a sentence after sentencing? Now, I'm thinking that they can lower the sentence, but not raise it if that's the case. Is that true?
Well, you're going to love this, but this is the favorite attorney answer. It depends.
Yeah.
So I had, not only in law school, but before I went to law school, I had an attorney tell me the law is whatever a judge says the law is. And so that's sort of why. If the judge, should he be able to change a sentence after sentencing? I don't think so. I think that's an appealable matter. I think you can challenge that in court, unless there's some major justification for it. I don't know how he can either. Let's see what else we got. First, I am not going to comment on the Carolina and Fort Worth case. I'm simply, I wasn't there. I don't know. I mean, I'm surprised about it is all I'll say. Is how do you get found guilty when you've got the video? It boggles my mind. I wasn't there, but that's all I'll say about it. It just, I don't understand how a guilty plea came out of that. Should have been a slam dunk case. Slam dunk case. That's all I'll say about that. Because I wasn't there. I don't know what was and wasn't done. I just know I wouldn't have lost it. Put it that way. All right.
Isn't that
what else?
Baxter County as well?
What's that?
Isn't that Baxter County as well?
What? Where she was?
Yeah.
No, that's Bexar County, San Antonio. She's up in Fort Worth.
Bexar County.
Yeah.
I like to call them Baxter. They seem to have a completely experimental law system down there.
Oh yeah. I've been dealing with Bexar County. I even sent a letter to the sheriff threatening to sue him for the way he was running his courthouses, violating the law and everything. I'm like, all these people come here because someone said you broke the law and now you're going to answer for it. And yet you, sheriff, your own deputies here aren't following the law. So I threatened to sue and I haven't had any problems since. So that letter worked. No, she did not plea out. Let's see. Can she appeal? You can always appeal if you've got something to appeal on. From what I'm hearing, I don't think any of the reasons for appeal were preserved. Motions weren't filed, objections weren't made, and if you don't file motions that are denied and you don't make objections that are overruled, you're not going to have anything to really appeal on other than lack of evidence. I mean, I guess you can claim lack of evidence, but when you do lack of evidence and it goes to the appellate court, the standard of review is in light most favorable to the winning party, which is the state. So she could probably do ineffective assistance of counsel. I didn't watch the case. I have no idea. Can you record in court? Not if the judge says no. If they allow your own
history on that.
Yeah, I would really like to see that law changed.
Can anyone tell me when the cameras were finally forbidden in court? What trial was it that actually did it? No, the answer is going to surprise you.
I actually don't know that one.
It's the Lindbergh case, the Lindbergh kidnapping case. They had the place wired so much that nobody could even move around, and there was 2 people who was actually electrocuted and had to be carried out of the the courtroom because of all the cameras and electric and radio and stuff that was trying to attend. It was that's when that and the flash bulbs. Those were the objections. The electrical cords and the flash bulbs. Be honest with you, that is the standing standard in why they have suppressed cameras in the courtroom, and it still stands. That was a piece of trivia I just looked up about 2 months ago.
All right. Well, hey, I appreciate you, man, and I'm going to let some room up here for other people.
Thank you for working. You're doing a wonderful job, man.
All right. Thanks for coming on. Again, the link is up there. If anybody wants to join, you got some questions or whatever. Just like Nissim did, you can just click on the link there and I'll see you and pop you in if you got something to say you want to ask about. Manual 1 2, why are they not assigning cases randomly? That's a good question. Now, one of the things I did learn, at least up in Tarrant County, and this might help answer your question. I know I meant to talk to you about this, but I probably just kept forgetting. But apparently the way that they assign prosecutors in Tarrant County is alphabetical. So if you're someone that gets in there a lot and you keep getting the same prosecutor, it's because they're assigned alphabetically, not randomly. And there's no requirement that it's random. That would be, hard on those smaller counties that only have one district attorney or 2 or 3 district attorneys, but hundreds of cases. So I guess that's the answer to that one. I didn't know that. I actually heard some people talking about it because one of the other attorneys was looking up a client and he was like, well, what's the last name of the defendant? And he says, oh, okay. Yeah. So I'm only D through F or something like that, whatever they are. And I was like, oh, okay. That was just me overhearing something. So it sounds like that's how they do it. I never asked about it, but that's how it sounds like they do it. All right. We got someone here that, let's see, Kersey. You're on here. What's up?
Hi, can you hear me?
Yes.
Okay, good. I need your help down here. It has to do with a dog attack and then incompetent officers handling that. What happened in my yard? A dog busted in my yard, and they treated me like dirt. And I had a witness and 3 kids here, and my dog stood between my locked gate and the dog that was busting through the gate to get at those kids. And that dog.
Where are you at?
I'm in Bandera County.
Oh, you're down. Yeah. See, and so what I'll tell everyone is I'm not taking any new cases until at least June. And I'm logging, I'm essentially getting rid of all the cases I've got, as they fall off. I don't take new cases to replace them because in January next month, I'm going to be working for an activist organization down at the Capitol, trying to get some of our laws changed. And so for 6 months from January to June, my focus is going to be on fixing the laws to avoid all the nonsense that we have in the courtrooms.
Well, this happened in April, and then that dog came back in July again, and it was unbelievable. I wound up in the hospital, and it just gets worse from there. But I did get a recording of the deputy just a couple of weeks ago. Not the deputy, the sergeant that came out here back in April. And I got a recording of him about a week ago apologizing to me for what they had done to me, because it got 10 times worse based on what they did.
And I know there's a lot of civil rights stuff out there, but I really stick to just First and Second Amendment stuff.
I'll just jump to the chase. Is there any way you could help me find an attorney? It's not necessarily a civil rights thing because they harmed me. I wound up in the hospital because of what the officers did.
Well, that's what makes it a civil rights case. I mean, unless you've got a personal injury also, but that's what makes it a civil rights case.
It's really hard to find it's really hard to find an attorney, period, here, if you're the victim of a crime, and I've had lawyers tell me this, the mentality of the jury here, it's awful. So I got people lined up.
It's that way everywhere because the way that the system is, it completely dumbs down what the purpose of a jury is. And we as attorneys, a lot of times are restricted in what we can and cannot say to a jury. And especially when it comes to things like jury nullification. But there are ways to ensure, if a jury's doing the wrong thing and an attorney is afraid of the jury, then that's a bad attorney because your job as an attorney is to sway the jury
I'm
and
saying
to educate the jury.
it's hard to even find a bad attorney here.
Yeah, I'm
you know
not
what I mean?
I'm not afraid of juries. I mean, I've seen some dumb decisions. I mean, gosh, I've had one loss, one trial court loss, and I'm 98% sure I'm going to win on appeal on this case. But like, I thought for sure, I'm like, there is no way. We didn't even put on a defense because I'm like, okay, they didn't even prove the elements of this offense. And yet he still got found guilty and they threw the book at him, because of the way that the prosecutor, of course, painted my client. And, the one downfall of the system is when you're doing closing arguments, the state does a closing argument, you do your closing argument, and then state gets the last word, right?
Yeah.
And the problem with that is they save all their bullshit statements to the jury until the second time around when you can't really oppose it. And
Right.
so, yeah, jurors it's very important that the attorney, you can't just be good at litigation. You can't just be good at finding people, and proving their innocence, which you shouldn't have to do. But you have to be really good at reading people. You have to understand the human psyche. You've got to understand what makes people tick, looking at your jury and then reading through their juror packets. And
well, I know that
what kind of jury do I want? And so
I know that I would be able to help the attorneys with that because I've been working the last 2 years volunteering online as moderators for law tubers.
Yeah.
And some of the big ones. But so I can help in that. Also, my background in education will help in that. But is there any way that I can talk to someone in your office and maybe they can help direct
I'm my
me?
office.
Well,
the reason I'm able to provide such low cost services,
mm-hmm.
and I think it's just a part of my OCD on things.
Mm-hmm.
I do everything. I built my own website. I made my own logo, except for the Lady Justice, a comic book friend of mine made that. But I made my own, firm logo. I do all my own marketing. Well, I don't really have to do marketing, but anything that I put out there that's got my logo on it. I do all the research for cases and motions.
Yeah,
and things.
I read up on you. I studied up on you. I read up on you. That's why I was like, man, I need a CJ. So
yeah, I don't have a staff, but my wife helps me.
If it can't be you, I mean, I wouldn't even mind going pro se for a while if my, physical disability right now will allow me to do that. If they'll allow me to zoom in.
When they revoke my license because too many people don't like me, my next step is to help people pro se their own cases.
I'll tell you what,
I do want to have time, and I won't be able to have time until I'm ready to. Hang on, I'm going to mute you here for a second. But one of these days, whether it's when I retire or whether they take my license, I really want to hammer hard helping people that do pro se and helping them understand, because you shouldn't, look, being an attorney, it's just an exercise in nonsense, right? You've got to get through the stuff of law school. Do they really teach you anything in law school? Not really. You read through the case files, the case books, you read through the case books based on the assignments, you go into class the next day, and what do? The professor says, okay, what happened in this case? What's going on? And then of course, you discuss some of the legal theories, underline it. And why do I say that? Because all you've got to do, and it's expensive, but it's probably cheaper than going to law school, get yourself these case books, the civil procedure case book, get yourself the criminal procedure case book, get yourself the evidence case book, get yourself the whatever it is that you're interested in, wills and estates, trusts, case book. And then you just read through that. You read through that, you study it, you get to understand the underlying philosophies and all that kind of stuff. The knowledge is one thing, procedure is the important part. If you want to go pro se, you really have to know the rules of civil procedure. You really have to know the rules of criminal procedure, and you've got to know the civil practices and remedies code in Texas. And you've got to know the penal code in Texas and the code of criminal procedure in Texas, if you're going to do those. So honestly, anybody can be their own attorney. Now, I've got a case, they say that only a fool has himself for attorney. Well, that's because you don't understand how to represent yourself. Or you probably realize if you think that only a fool has himself for an attorney, you probably look at yourself and realize you're a bad attorney. And that's why you don't trust yourself with your own case. I've got a case down south that where I'm charged with hindering a government proceeding by disorderly conduct. And I'm doing that myself. But what I'm going to do is I've got another attorney that's going to come in. And when I call myself as a witness, he's going to perform the and this is, I don't know that we're going to get that far, but then he's going to do the direct questioning of me. So even because it's a lot harder. It's just weird. And thanks for coming on. I don't know what I can do for you. I don't see. The problem is the kinds of attorneys like me, there's like literally maybe a half a dozen of us, and we all know who we are. And the problem is that there are so few of us that all of us are incredibly busy, and you almost have to kind of keep poking at them and going, hey, I know we spoke a month ago and you were too busy. What about now? Hey, I know we spoke about a month ago, but you were too busy then. How about now? And keep going around until you find one that's not busy, because what's weird is like in 1 week, you might have 4 cases just drop off because they were dismissed, or you won a motion, or there's a settlement, and now you've got 4 empty spots, but you don't know that, because what's going to happen is what I do is I generally, because I'm not out there, I've got so many cases, I'm not out there trying to find them, they're finding me. And so generally when cases drop off, I literally will start working on the other ones. And if somebody doesn't contact me in that little brief time, or vice versa, when someone contacts me in that brief time, I just take on their case, because I don't have time to remember, okay, how many people have been contacting me? Oh, I need to go out and see if this person still needs an attorney. I just don't have time for that. And so I wait for people to come back to me and, say, hey, are you free? And then I say, yes. But guess what? If you're someone that just talked to me 1 month ago, whereas a person who called me 4 months ago, and then 3 months ago, and then 2 months ago, they just kept calling at the wrong time when I was full. And so you kind of got to keep that up there. Is your case constitutional? No, it is not. Absolutely not. What's funny is me and my client, because I went down there to defend my client, we both got charged with the exact same thing on the exact same day. What's interesting is the only difference between our cases is that so we were both using profanity, but he was actually actively calling them name, profanity, but it's protected. It's protected speech. Doesn't matter. Whereas when I went up there, I was quoting case law that had those words in it. And then I summarized it by saying, so if I want to say fuck, and I want to say fuck again, and I want to say fuck again, I can do that. And there's nothing you can do about it. And if I want to say you're a tyrant, Mr. Mayor, I can do that. If I want to say you're a piece of shit city manager, I can do that. And that's when they gavelled me out, and I wasn't finished. They gavelled me out. And of course I'm like, wait, is my time up? What's going on here? You're violating my rights. And so I went back, and that's when they charged me, but they charged both of us. And so I filed the same motion to suppress because we're in different courts. Mine's in one court and his is in the other court. And I filed the exact same motion, just different names, one for me, one for him. And the judge in his case dismissed it because it's protected speech. But in my case, it was not dismissed. So that just goes to show you that the law is whatever a judge says is. All right. Hey, Kersey, thanks for coming on. I got another Brent here is going to bring him on. Is this Mr. McCain?
It is. I'm driving down to work. I got about another 2 hours to go. Can you hear me okay?
I can.
All right, good deal. So my question is, I told you about the Waco PD and the dog attack, killing the dog, responding to the wrong address. So that case was dismissed by an appeals court. And it was, I don't remember the proper terminology, with prejudice, without prejudice, basically meaning that they can't bring that up again, I guess.
With prejudice means they can't bring it up again. Yeah, it's dismissed. You can't try a different claim.
Okay,
Yeah.
that's what my question was going to be.
Well, if it's dismissed with prejudice, it's only dismissed with prejudice as, okay, I misspoke, or at least I probably didn't make enough sense. So let's say you sue a guy, or you sue, you sue a guy for retaliation, right? And it gets thrown out, but the statute of limitation, and he dismisses it with prejudice. You just can't resue him on that particular claim. If he says without prejudice, you can definitely refile with a different set of facts, or maybe clarify your filing. But that doesn't mean that even if it's with prejudice, that you can't sue him over the same thing for like false imprisonment. Maybe you find a different claim of maybe just excessive force or something. That doesn't, with prejudice, doesn't mean you can't sue him again. You just can't sue him for the same cause of action.
Okay, because this young lady's attorney did not even mention what started the whole thing was an error in dispatching them to the wrong address and blaming it on a piece of equipment, which I don't believe it could be. But anyway, yeah, that's what I was curious about.
Okay. All right. There you go. Hey, you drive safe, man.
Thank you.
Oh, sorry. I think he was getting ready to say something. I hit that button too soon. All right. We got another question here. Let's see if you wait. What's this? Did you figure out the power of attorney sign I sent you? Looks like giving the police to trespass without any thought. I'm sorry. Hey, Tim, can you rewrite that? I don't know if it's just me. CFW fired you and got another attorney. True or false? That's actually false. So I was never officially hired on those cases, but generally an attorney will act as if he's continuing to represent a client on something else. And if something else happens, because usually that person is going to keep the same attorney. So I was just operating under that assumption, and then realized that she hired someone else. So I was never fired because I was never officially retained. There was no firing. We never had a contract, at least not for those cases. Let's see. A dog owner threatened to unalive me. Sergeant didn't write a report on that, so I'm dealing with harassment verbally and online. There he goes. Did you figure out the power of attorney sign I sent you? Looks like they are giving the police to trespass, I guess, power to trespass without talking to the property owners. Any thoughts on how that affects 1A auditing? Well, first of all, a police officer cannot legally trespass you from land that he doesn't have a superior possessory right over. And that can be given through permission, a target person saying to the cop, hey, we want to trespass this person because this is the third time that we caught him stealing. But if you're in a target, a cop can't just come up to you and say, hey, I'm trespassing you. Well, why? Well, I just don't want you here. Well, who in target told you that to trespass? No one. I'm just telling you you're trespassed. I'm trespassing you. Well, sorry, buddy. You don't have the authority to trespass me. You don't have the authority to trespass warn me. Unless that property owner, because it looks like it says they're giving the police permission to trespass. So, I don't know. I guess I don't know what you're talking about, because if you sent me something, I probably haven't looked at it. I've been so busy since September. I learned a valuable lesson as a rookie attorney, and that is you never take 30 days off in a row. Okay. At most, maybe take a week. You're pushing it with 2 weeks because there's just so much going on and there's so much that you have to push back. So I took all of September off, and that meant, and of course I still ended up having to work. I tried to take September off. I pushed all my hearings and everything outside of September. And that made my October, November, and now December incredibly backed up. I can't believe 1 month out made 3 months of hell. So, but I don't see, unless the landowner, like if I had, let's just say my property, I could theoretically tell the police, hey, I don't want anyone on my property, or I don't want elves on my property. And you have permission. If you see any of these types of people on my property, you have my permission to trespass them. But I mean, absent something like that, I don't know how, like the police, unless the police are given specific orders, anyone with a camera trespass them. But if you live, I don't know. That just doesn't sound right to me. Yeah, I know. It was a crappy vacation, Emily. Let's see. LOL. She told you. Told me who told who? Eye of the night. Who told who what? Let's see what else. What's the difference between no trespassing and no trespass sign? There isn't. They effectively, they both mean the same thing. Just like putting up a purple, if you just painted your posts on your fence purple, that's also notice. But no trespass, do not enter, no trespassing, all of that stuff. It all means legally, it effectively means the same. Oh, gotcha. Okay. Yeah. She, I'll tell you, I'm probably not as upset as her, but I'm upset with how my September went, my so-called vacation, because nobody would just leave me alone, I get that from my wife all the time. Yes. Yep. Hey, where would we be besides 6 feet under without them, right? I mean, the number of times, probably literally, she saved both of our lives. I can't count, but definitely my own. Let's see. Purple. Yeah, that is old school. But you know what? You see it all over the place here in Texas. And if you don't pay attention, you don't know what that means, you can get yourself in a lot of trouble. You can get yourself in a lot of trouble. And I don't just mean legally. I mean like getting shot. If you don't know what that purple paint on those on your fence posts means, you're in for a lot of trouble. Do a Google search. What does purple paint on a property mean in Texas? They don't have to put up words at all. They just got to put up some purple paint. You're a fortunate couple, celebrate your relationship every day. Well, I wish I were less busy to be able to do that. No, but yes, I definitely am fortunate for sure. See, the trick is you get them young when they don't know any better. That's kind of how I did it. You sent the picture of the sign to my phone. Oh, geez. Who knows where that is? I don't know if I've seen it or not. I've got so many things going on. Usually what happens is if I see a phone call and I don't recognize the number, I literally just don't answer it because I'm doing something. I'm either in court or I'm working on a motion, or guess what? I'm trying to relax because all I ever do is work. And so if I'm trying to relax, which isn't normally during the day, I'm just not going to answer the phone. I'm not one of those attorneys that you can call at 2 a.m. and say, hey, I just got falsely arrested. Can you get me out of jail? I am one of those attorneys you can leave a message. And when I wake up in the morning, I'll do what I can. But yeah, I mean, you can call it's 8 o'clock right now. My phone's already off, or at least the ringer is off, except to people who are in my favorites, which is essentially my family. They're the only people that can get through. And everyone else, I don't even hear it ring. I don't even see it. It just rings silently. Is there an outfit that will supply the documents and forms I need to go pro se? So, I mean, I don't know if there's a free company out there. I used to use LegalZoom for a lot of stuff, but I don't think they do sort of pro se and all that kind of stuff. As far as litigation, I think they just do really easy things like forms, but I don't know that they help with motions. The best thing to do, honestly, is get yourself into a Chat GPT type environment and, ask Chat GPT. And I've got a legal AI, which is how I'm able to do as much as I do because I've got a legal AI. It's Lexus Plus AI. Hey, Manny, thank you so much for that, my friend. Thank you, Manny, for the $20. Definitely appreciate you. By the way, yesterday, for those of you who don't remember or don't know, yesterday was the birthday of the Second Amendment and the First Amendment. Was yesterday. So happy birthday to the Second Amendment. And there's that $20. So thank you, sir. Appreciate you. Appreciate you. Let me get back up here to my link that I lost so that if you want to join, I am just taking people on live. Look, if you want to cuss me out, you want to just ask questions, you want to talk, this is the podcast to do it. I'm just doing this because I'm trying to wear myself out so that I'll go to sleep, because generally the night before the start of a trial is all I'm thinking about is the trial. Okay, what do I got to do here? What do I got to do there? What, how am I going to attack this witness? How am I going to attack that evidence? And I've already done all that. I've already got my folder ready and my binder. I've got all my exhibits in there. I've got all the motions that we filed. I've got all of the state's evidence that's in writing. I've got my videos on a flash drive already cut out. I've got my notes for each of the videos and time hacks and all that. So, I'm ready, but it never fails that the night before a trial, even though I literally do not get nervous at trial. I'm not nervous about voir dire. I'm not nervous about opening statements, closing statements, questioning witnesses. I didn't realize this case I did up in Abilene, man. I don't know how I didn't pay attention to it, but it's the first case I ever had where every single seat was filled in the audience. And I was like, man, but I don't think about that kind of stuff because all I'm thinking about is my client. And, if I thought about things that had nothing to do with my clients or my client's case, I'd be way too distracted. So I'm literally just focused on what's going on with my client. Hey, really quick, I wanted to kind of show this. I don't know if it's going to be backwards. Oh, it's not. Okay. So there we go. That 484-350-194. If you can see that, I'm covering up some of the other numbers that aren't necessary, but 484-350-194. If you go to any First National Bank of Texas or First Convenience Bank, and you can donate to that fund. It's also in the video description. I am raising money for a scholarship that I started already. My first scholarship was this year. And so next year I'm trying to make it even bigger, and I'd like to make that scholarship, statewide instead of just locally. As a matter of fact, I think that $20, I'll put that in that fund for the scholarship. Is there a period that you have to do so much pro bono work to keep up your bar? No, you don't have to do any pro bono work at least not in Texas. The bar does ask or challenge attorneys to do at least 50 hours a month, or I'm sorry, a year, 50 hours of pro bono service a year. I would say I do that each month. I wonder let me see how many pro bono hours I have, because you can report that, and it's good because it gets you put on this neat little list, and people go and look at it and, oh, this guy does a lot of pro bono work. But what's weird is a lot of my pro bono cases, for example, I was at a case last week at a hearing, and somebody heard what I was saying and kind of how I was talking, I guess. Let's see, view and report pro bono. So 2024 so far. This doesn't tell me how many total. It just gives me a whole bunch. 12, 24, 30, 40, 50, 60, 74. That's why you're miserable. 95, 106, 112, 119, 128 hours. So I got 128 hours this year. of pro bono that I've done. And what did I do last year? Did I even report last year? I did. Yeah, that's right. Oh, geez, I got a whole bunch there. There's 100, 120, 130, 143, 53, 63, 69, 169, 172, 188 hours last year for pro bono. But yeah, the bar just asks you to do 50. That's it. Let's see. Yeah, I know it's like one pro. It's not a lot at all, which is why I don't understand why so many attorneys, and it's not required. So a lot of attorneys just don't do it. But I don't know. How many hours is average? See, I would think 50 would be the average. Everybody's got time to do something. Like when I look at my bar hours here, so like let me go back to them. For example, one case I only did 3 hours worth of work on, but one case I did 18 hours worth of work. And I think last year there was a case I did like 80 hours worth of work on total. It was a long drawn out case with a lot of depositions and things. But, you know, like this one was 3 hours that I reported for one case. And usually when the case is over is when I report those hours. But all right. Do attorneys ever sue other attorneys for incompetence or RICO type stuff, colliding against the client type action? Well, again, you got to watch out. If you're going to sue somebody, you got to make sure there aren't any conflicts of interest there. I know I personally, in the last year and a half, have filed 3 ethics complaints against attorneys and 1 ethics complaint against the judge. That is unheard of. You know, a lot of attorneys are a lot like cops. They try to protect their own, do everything to protect each other, sometimes at the expense of their clients or the public. I'm not like that. If you're screwing up, I tell people all the time, you know, when they call me, oh, you know, because when they say I'm represented, I'm like, well, I'm sorry, I can't provide you any advice. Well, I'm looking for a new attorney. I'm like, oh, okay, well then, if I can talk to you for that purpose, but I can't talk about your case necessarily, except for in basic ways because you got an attorney. But a lot of attorneys just won't sue each other. I'm actually defending another attorney right now, you know, because there's a potential there. But no, they don't like to sue each other, but I do. I don't have any problem with it. There are 2 attorneys down in, actually they're both prosecutors that I'm suing, on behalf of the client, of course. I can't remember where that is though. Notification: this property is covered by power of attorney by order of the Galveston Police Department. Violators will be what? Yeah, I don't even know what that means. That's weird. This property is covered by power of attorney by order of the Galveston Police Department. Galveston Police Department ordered a power of attorney, or that's weird. I don't know what that means. This property is covered. Yeah, I don't know what that means. I've never heard of that. I don't think that's a no trespass. Yeah, you can sue Galveston under RICO. You just make sure you meet all the elements. You know, look under the RICO law and find out what's necessary and then meet the elements. Yeah, you can sue. All right. Looks like, so I've got about 2 minutes here. I'm ending this. Okay, send a picture. Are you not allowed to give legal advice? Are you not allowed to give legal advice to a person represented by a lawyer, even if you are not an adverse party? So yes, as an attorney, if a person is represented, I am not supposed to give legal advice as to that representation. Now, what I can do is I can tell them what their options are. For example, someone calls me and they say that, you know, hey, I've got this attorney and he's not doing anything. I've left emails, I've called and left messages, and he's not contacting me. I'm allowed to, so I can give advice, explaining to these people what their rights are as it relates to ineffective assistance of counsel. And what's funny is, it's amazing how quickly an attorney will respond to you if they get an email saying, all right, this is the last time I've asked about this on this date, and this date. You refuse to contact me. You refuse to get back to me. I have no idea what's going on. And you're my attorney. And if you don't respond to me in 24 hours, I'm going to report you to the bar for violating your ethical duty to communicate with your client. And by golly, usually within half a day, that email is responded to. Merry Christmas, Nimrod. Thank you. And let's see. What about pro se? Can you give advice? Wait, am I pro se? Well, I can give. Yes, pro se people. You can. I have several clients right now that are pro se, and they just pay me to write their briefs. Like they send me the fact pattern. What are they looking for? And they just want to make sure it's a good argument, a good brief, and that it's written correctly. And so they hire me just to draft. And that's the same thing, providing legal advice to pro se. Yeah, you can do that. And with the attorney's permission as well, I can give legal advice if the client, comes to me and says, like, for example, sometimes a person will be represented by a criminal attorney, but they want to hire me for a civil matter. Then I can talk to them because it's a completely, I can talk to them even about the criminal matter, in reference to the civil matter. And I always like that because if there's a criminal case going on and it's most likely to win, or even if it's not, what I would need is, I could help the criminal attorney with which motions to file that will help me in the civil case, or even questions that I'd like the criminal attorney to ask a witness on the stand, because that's like a free deposition. And if I can get a free deposition, all the better. And I can send that attorney kind of questions that I'd like them to ask in the criminal case so that it's preserved for the civil case. I do that a lot. What do I do if I don't hear nothing from the attorney general after filing a complaint for 30.6, 30.7 signs? Well, I don't know. I guess you can call down there. And I bet you there's, I don't know, it can't be much of a backlog. I mean, gosh, we've been open carry now for 9 years. I don't know. Well, I take that back because I'm still taking down signs. I'm still having signs taken down because I'm seeing them all over the place. But if the AG doesn't respond, it may be that you didn't do something right, because you are supposed to, there's a process that on the AG's website about how to do that. If you didn't do the process that's required, they'll probably just throw your complaint away and you got to start from scratch. Or they're just way behind. They've always been way behind. Thank you guys. I appreciate it. Yes. I try to help. Again, this was just nothing really focused. I just wanted to get on, talk to everybody, kind of clear my mind before the trial tomorrow. Again, don't forget Manuel Amata's trial. If you'd like to watch, and please be respectful of the rules. Don't interrupt. Don't cause a scene. Just sit and watch if you're able to. Just sit and watch, and then it'll be starting tomorrow, County Criminal Court 9 on Belknap, and it starts at 9. But 9 o'clock is just the voir dire, so I don't anticipate anything happening any earlier than 1 o'clock. So if you're able to get over there 1 o'clock or after, I anticipate if we get started tomorrow with the case in the afternoon, I don't know how many witnesses they're going to call, but it'll probably take all afternoon just for the state's case. If they rest, then it's our case. I think I'm going to be able to destroy them during the state's case. So I don't even think I'm going to put anybody on the stand. I don't think I need to. They're the ones that have to prove guilt, not the other way around. Yes, Texas AG is busy trying to keep THC and weed illegal, which is absolutely insane. As a veteran with PTSD, I have trouble sleeping as it is. And I used to take medications for it because it helped with the nightmares and it helped with sleep. But then what would happen is if I had to get up in the middle of the night to go to the bathroom, these medications would, as soon as I stood up, they dropped my blood pressure and I'd pass out. My wife would find me in the living room or in the kitchen or in the bathroom or something, wherever I am, just literally passed out on the floor, probably thinking I'm dead. And so I stopped doing that. And then I found these gummies that are designed for sleep. that have THC in them. And I'm telling you, I have not slept better than when I take one of those gummies. And as somebody who deals with PTSD and nightmares still to this day, I don't have those. I don't have any problem sleeping. I don't have those nightmares ever since I started using these gummies instead. So I will go to fight. I don't care what party he's in. I will fight the Texas AG and the lieutenant governor over this idea that they're going to ban THC. You know, we need to just ban laws that restrict marijuana use, because it's just nonsense. And I mean, I've got a case. I can't believe that we just lost a motion to suppress. And unfortunately, I don't think the client's going to be able to afford to appeal, because I would really love, I am taking the gun case. I guess I could take both at the same time, but I get so frustrated. Anyway, all right, guys. Order them from Amazon. I've got a little shop here next to my post office box that sells them, and I like the little small businesses. And I'm 100% disabled as well, and I'm going to fight them on this, because they're going to hurt veterans. So they'd rather me be taking medications. And by the way, Dan Patrick, you look at his financials, and the single largest industry that donates to the people who are pushing to ban THC, guess, pharmaceutical companies. That's their biggest source of donations. All right, guys. You guys take care. Be safe. Be free. I'm going to end this stream. I appreciate you guys hanging out. And again, check the description of this video. And if you're able to, you throw $10, couple $100, couple $1,000. Again, this is, now I will say, just complete transparency right now, the 1791 Foundation is still in. As a matter of fact, I've got right here. I mean, long story short, I'm not a nonprofit, so I don't want anyone to get the idea that I'm a nonprofit. Where are my bylaws at? Oh, here we go. I mean, here's the Articles of Confederation that I drafted up, and you can't see it because it's white paper. I don't know. Anyway, I've got my Articles of Incorporation. Once I get through that process, then I can apply for my 501c3, so that, and I consider it an educational nonprofit. It is geared towards getting our students, our young people, interested in the Constitution, and focused on it and reading it. And I have an essay that I require that talks about an aspect of the Bill of Rights that I want students to talk about. And that's sort of my goal. And then it's also, of course, they have to talk about how committed they are to the Constitution, and take an oath that should they win the scholarship, that they will support and defend the Constitution for the rest of their lives, kind of thing. So I'm trying to get people more focused on our constitutional rights, because our schools aren't doing that. And it's just also a way for me to get them prepared for the woke nonsense they're going to have to deal with once they get there. All right. All right. That's it, guys. Take care. Be safe. Be free. I'll talk to you next time. Again, please donate down there if you can. It's not to me. Again, it's to the foundation. 100% of that goes to scholarships. I did a $1,000 scholarship this year. I would love to do at least 5 and open it up to the entire state. To do. Now, obviously, if the bigger it gets, I can start going to Oklahoma, start going to New Mexico, wherever, and start taking, applications from all around the country. I mean, if I've got, if I had $50,000 a year, I could give a scholarship out to a student in each state, and we could get that Constitution spread out there. So, there you go. And with that, I'm really going to leave now. Take care. Be safe. Be free. I'm going to try and get some sleep. Bye.